All right, welcome everybody. Thank you so much for being here. A special thank you to Suzanne for being here with us today. We're going to go ahead and get started. And how to introduce Suzanne. She is our go-to person whenever we have a question about anything and everything, or we're stuck, we say, call Suzanne. That is an expression around the workplace at CASA. Let me back up. I'm sorry. I'm Sarah Glasscock. I'm the Director of Advocacy at CASA Nashville. So I oversee the program staff and our trainings, and Suzanne has been kind enough to join us today to talk about Court 101, basically. Suzanne has 28 years of experience being with CASA, both as a volunteer and as a staff member for 16 years. So when we're stumped, like I said, we call Suzanne. And so, Suzanne, I will hand it over to you.
Okay, thank you, Sarah. Thank you. Okay, uh, please feel free to jump in, ask any questions. We have plenty of time here today, so thank you all for being here. I did want to start in with, how things get started as just a little reminder from the initial report of abuse that gets called into DCS to the preliminary hearing. So when a call comes in, a CPS investigator, that's Child Protective Services Division of DCS, responds and communicates with their supervisor during the whole time. And occasionally they'll contact a DCS attorney. And if they're still not sure about should the child be removed, there is a magistrate on call that they can actually contact to help make that decision of should we remove the child or not. So when they decide to remove that child, the first thing they'll do is ask the parents, is there a family member or friend who could pass a background check and who would be willing to keep your child, someone the child knows, so that it isn't so traumatic for the child. If the parent comes up with someone, then DCS goes to that home, does background checks on all the adults in the home, checks to see if that adult has any prior experience with DCS. And then if it's agreed by everyone, they'll do a least drastic alternative by placing the child with that relative or family friend. And the parent gives that adult a legal power of attorney so they can do things like seek medical care for the child, get them enrolled in school, and so forth. And that power of attorney does have to be renewed it used to be 30 days. I don't know if it still is. However, if there is no one to take the child, then foster care is the only option.
Suzanne,
And yes,
real quick, we have a couple questions. So
sure.
Melody asked, when the adult suggests someone to when the child can move in. So I guess the root of the question is if a least drastic is presented, how long does it usually take for them to check that person out and vet
They
them?
they do yeah, they do it pretty much right away. They'll typically get someone else at DCS will be going in, checking background checks and seeing, have they uh, had any past experiences with us with DCS. And then, they get somebody out to the home to check it out. It may not be the one who is removing the child, it could be somebody else from DCS. They try to take the child from the parent's home to that relative's home or the least drastic alternative.
Okay, and I think that's the same question was the other one. Thank you.
Certainly. I also wanted to touch a little bit on petitions and motions. Petition asks the court to make a finding like, is the child abused or neglected? And then whose fault is it? So if you remember reading the original DCS petitions in your case, it will list in bold type, was this child abused or neglected? If so, whose fault is it? Basically, is what, and they'll list why, such as it's the mother's fault because she was using illegal drugs, or whatever reason. Um, and then they'll move on typically as they're discussing that petition to what are we going to do about visits? Are we even going to have them? And then a perm plan is created around the allegations in that petition. In other words, if a child is removed because a home is filthy and the parents aren't working and mom's depressed and won't get out of bed, but there's no sign of drug abuse, they can't put, uh, the parent will undergo regular drug screens because it wasn't part of those initial allegations. Now, something can come up, some proof can come up in the future, but basically the plan is created around that
So
petition.
real quickly, just want to
Mhm.
jump in. So that petition that Suzanne referred to is that really thick document that you get at the beginning of your case. Sometimes we call it a referral packet, and it looks like a bunch of stuff that's been copied and pasted, and then in the middle of it, it'll talk about the actual story of why that child came into care. So just wanted to share that. And
Mhm.
then how long does it take between the preliminary hearing when the child goes into care and the permanency plan hearing, Suzanne?
It's supposed to be within 60 days.
Supposed to be.
With, within 60 days of the, yeah, it's supposed to be within 60 days of the preliminary hearing. So a motion is a little different. This is kind of, you're usually into the case by now, and somebody wants to change something. Say the parent's attorney comes forward and says, the parents are doing really well. They're working their plan. We want unsupervised visits. Then we may come up with something new. But typically it's, let's see, it could be that CASA files a motion asking for therapy for the child that they haven't been getting, something like that. So we can also ask the court, file a motion, ask the court to review it for specific reasons, saying new information has come in, maybe about the parents being arrested for domestic violence or for drug abuse, something like that.
Can I add to that? So
Sure.
filing a motion if you were thinking about filing a motion on your case, that would be kind of a air quote drastic kind of thing. Would hopefully have a CFTM to discuss whatever barriers were happening for whatever the action was that you wanted to have happen on your case. But we can do that if you're just absolutely stuck and things aren't moving forward, a service isn't happening, that kind of thing. And you would truly want to get the guardian ad litem on your side on that, and ideally, so that you have that kind of both of you in support of that. That makes a stronger case.
Hey Sarah,
Yes.
can I jump in really quick too? Because this just happened to me this morning. But when you guys get a motion, it's always good to check in, maybe with like the guardian ad litem, and to ask what it's pertaining to, because sometimes those motions are just for severe and complex. And that's just basically saying this case has exceeded the hours, the attorneys need to be continued to get paid. And we don't have to attend those, but sometimes, I'll just see motion and I'll think, oh, they're wanting a change and something pertinent. And then you get there and there's really no need to go. So
Yeah.
that's my little PSA.
Yeah. Also, if you are thinking a motion should be filed, please see your team leader because, yeah, there needs to be a discussion there about that. Now let's go into types of hearings. It all starts with that preliminary hearing with Magistrate O'Neill. DCS has to prove that there was reason to remove the child and to go forward with their petition. At that preliminary hearing, the parents might testify if they want to be heard. They can, they have that right. In the end, if the court rules that there was reason for removal, custody is given to DCS. The court has sometimes dismissed, upon occasion, they'll dismiss those petitions and say, no, there's not enough proof or whatever. It's rare because the DCS attorneys know what they're doing when they file. And, on occasion, it can be dismissed. But if it's moving forward, then Magistrate O'Neill will assign it to either Magistrate Robertson, Magistrate Sumner, or Magistrate Wilhoit, one of those three. They hear the neglect dependent cases that DCS has. And they'll assign it to a courtroom. It stays in that courtroom the entire time. Should the child exit custody and then come back in months or years later, they'll look up and see, well, who heard this, and try to put it back with that same in that same courtroom. And yes, the perm plan should happen within 2 months. Typically, CASA staff are at the preliminary hearings. They get referrals and they go to see what's happening. Is the child going to stay in custody? Because on occasion, a relative will show up at a preliminary hearing asking for custody. And yes, so it's not typically something a volunteer would go to. Then there are appearances. If a parent hasn't appeared in court, the court wants to make sure that they've been served with a petition and that they have legal counsel if they want it. So that's what an appearance is about. It's, if the parent shows up, it's a good place to meet them if they haven't shown up before. Shelter hearing is that typically, well, I can come out of any hearing, but if all of a sudden, a few months down the road, grandma moves to town and says, I'll take the kids, then they'll have a hearing on, is she appropriate placement to get the child out of foster care. Settlement hearing is when, okay, so Magistrate O'Neill has put this case into another courtroom. There's going to be a trial. But first, let's see if maybe we can reach a settlement, an agreement between the parents and the Department of Children's Services. CASA does not have any input in this. The parents may negotiate. They may agree to the allegations. They may get DCS to change the allegations to something they agree to. It's kind of like in criminal court. You're going to plead guilty, or you're going to see if they'll drop the charges and then I'll plead guilty to that. It's that sort of thing. But if no settlement is reached, then it's set for a trial. And typically that's going to be about 2 to 4 months out, depending on how heavy the dockets are.
Can I speak real quick
Mhm.
about CASA court reports and just kind of expectations around that? So we at CASA Nashville ask that our volunteers prepare court reports for permanency plan hearings and trials, whether that's usually TPR. However, and let me back up. We ask that you provide your draft of your court report a week before that hearing so that we can review it, your team leader, and submit it to that courtroom 5 business days before that proceeding. So that's for permanency plan hearings and for trials.
I just want to,
However, anytime you're in court, that's a chance to submit a court report if you would like to get information in front of that magistrate. So you have the opportunity to prepare a court report if you would like, and please
Mhm.
keep those timelines in mind when you're submitting those court reports. But when we require them is permanency plan and trials. And I think I saw Noelia's hand.
it's me, Alexa. I also encourage my advocates to do it during, if you have a motion hearing, if it's like regarding visitation, or you
Mhm.
have an opinion on whatever that motion is.
Absolutely. Thank you.
Okay, the permanency plan hearing, hopefully within 60 days of the child's removal. And then once a year, at least once a year, to update it. With infants, they may do it every 6 months. The child or children must attend the perm plan hearing. CASA does file a report. There are only so many goals for the permanency plan. One is return to parent. Another is exit custody with relative, if maybe there's a relative out there who wants the child. Adoption and permanent planned living arrangement. Sometimes teenagers don't want to be adopted, and going back to parents is not a possibility. So the child themselves may opt to just remain in foster care until they're 18, or even possibly an extension of foster care. We can work 1 or 2 goals at a time, but no more. So you might have return to parent and adoption. We see that frequently. It's important to make sure that DCS is working both goals. They're supposed to be working both at the same time. In other words, once adoption's added as a goal, if the child is not in a foster home that's willing to adopt, then DCS needs to be working to find one, just in case.
To add to that, there has to be a goal on the permanency plan, even if that youth does not want any of these options. I work with a 16-year-old who is so done with DCS and his time with DCS, but they keep adoption on his plan because they have to have something on there, and he does not like that that's on his plan, but they have to keep it on there. And so every time we spend time talking about it, but they have to have something on there.
Yeah, and that's because, there's 18 is not a magic age, and they may think they want to be on their own, but it would still be great if they had some sort of family. Then we have the trial and disposition. This can come up with the original DCS petition with the allegations against the parents or whomever, or it can be on a motion. It can be any type of a trial. People testify. You could be called to testify. So then the magistrate would rule on, will he go with what the petitioner asks or not? From there, it goes directly into disposition. Typically, it's heard right there in the courtroom right after the trial, but not always. Disposition is basically, where's the child going to stay for now? What's happening with the child for now? It can be set, let's see. What was I going to say? I'm sorry. Sometimes the disposition is put off because the magistrate won't rule right away. They want time to think about it. Sometimes someone in the courtroom, one of the attorneys, will ask for it to be bifurcated, which means set it for another date, or the magistrate may say, I want the team to go have a child family team meeting about specific issues, and then we'll come back and have the disposition. The disposition is where your CASA file is important. CASA report is important. Yeah, the report usually doesn't pertain to the trial so much as the disposition, though it could, I guess, in a TPR trial, it definitely could.
Suzanne,
Mm-hmm.
can you speak
Yes.
to what it's like to testify, when you might know about whether you're going to testify, what that would be like?
Sure. Okay, so when you testify, you have a lot more power than you probably think. When you get up there to testify, typically they don't want you to bring any notes with you, but if you feel it's going to be important, you have to make sure that all the attorneys have copies of those notes in front of them. And when you get up there and someone asks you a question you don't understand, you can say, I don't really understand that. Can you restate it? Or you can say, I don't know. It's okay when you're testifying to say, I don't know. It's okay to say, I don't remember. So basically, you just get up there and answer the questions to the best of your ability. You're, they don't expect you to be, what am I trying to say? A professional. Oh, okay. I don't know. Anyway, it's okay to just be yourself, to say you don't know things, you don't remember things. If that helps any, you just do the best you can.
Yeah, that's really helpful. And sometimes you might not know until you get to court that they're going to ask you to testify. And the advice that I was given is to just keep your answers really succinct and to answer yes and no when at all possible.
Mhm.
That was the advice I was given.
Yeah, that is good. Yeah, you don't want to elaborate on things. And then there are review hearings when the court wants to know how things are moving along. Um, you know, you can do a CASA report. Sometimes it will be a review hearing for a specific reason. It's like, well, did the child's therapy begin? You know, that sort of thing. Motion hearing is it can, okay. First of all, motions filed, a lot of people file motions. So initially it goes into this motion docket that has a whole slew of motions. At that first hearing, they'll say, is everybody in agreement? And if everybody is in agreement, magistrate will look at it. And if magistrate agrees, they'll go, okay, I agree. That's it. But if somebody does not agree and there's going to be argument over it, they don't hear it at that time. They set it out for another weeks, months, whatever, and they have a trial about it. So you could do a report at that full hearing. Any questions on that? No. We rarely ever go to child support hearings, but if the parents you're working with find out they have child support hearing, you're probably going to hear about it because nothing makes them more angry than for DCS to come take their children and then want child support. However, DCS is not very diligent about asking for child support. Most of the families we work with are having a hard enough time, and DCS recognizes this. The court recognizes it. They're having a difficult time as it is, and that usually includes financially. So they try not to burden the family further, but they can ask for child support at any time. We do not attend that typically, but you can go and be there. I think I've attended maybe one or two where just the week before the kids started a trial home visit or something happened that I feel like child support court needs to know about. Child support is heard by Magistrate Kane. It's not heard by the magistrate who typically hears the case. Don't know why that is. It's just how it's set up. Magistrate Kane's courtroom is downstairs, the one closest to the restrooms back there. So she hears it and she may not realize that there's some brand new information that could affect whether they assign child support or not. And if you think that she needs to know that, you can always go down there and ask to be heard. And she will definitely hear you. And then we have termination of parental rights. These are heard by Judge Calloway. It's in two parts. First, there are appearances. The appearance, once again, it makes sure that the parent has been served with the TPR petition and that legal counsel's in place if they want it. And then they'll set a trial date. We have no input in this part of it, but it could be important to be there to make sure that you're going to be, though the trial date is good for you. If they're looking for a trial date in court and you know how these are done, everybody sits around and goes, oh, I can go then, I can't go, I have this, I have that. And the court wants to know if CASA can be there for that also. So if they want to schedule a TPR trial in the middle of your family vacation to Europe, whatever, tell them, let them know, and they'll be sure and schedule it at a time when you can be there.
Can I
And
add
you
to
get to,
that?
sure.
When I was a team leader, I would go to those to see who would show up to the appearance, because sometimes I would see that a parent who had been seemingly uninvolved for months or however long would be at that appearance, and instead of setting, a trial at 1 p.m. that they thought would go quickly, and because maybe no one was going to show up, they would set an all day. So sometimes I would go to those just to see who would show up because that has bearing on perhaps what's going to happen in the future.
Right. Yeah, good idea. And then there's the trial itself that is also heard by judge. The reason Judge Calloway hears the TPR trials is because any decision that is made by any magistrate other than Magistrate Calloway, remember, she is the elected juvenile court judge. She appoints all the other 9 magistrates. Any decision they make can be appealed to her. And she hears it, she hears that all over again, that trial all over again, and to see if she agrees with the magistrate or not. To avoid that step or possible step, she just hears the termination of parental rights trials herself. We do file a report for that, could be asked to testify. The parents, if she orders the rights to be terminated, they can appeal to the state court of appeals. They have 30 days from the day she signs the TPR order to appeal in the state court of appeals. Yeah, so that's why. And if it does go to the state court of appeals, you can go and observe, but we're not heard there.
Can you talk a little bit about surrendering?
Oh, sure, yeah. Parents can voluntarily surrender their parental rights. When that happens, the court treats them with great respect, and everyone in the court, CASA attorneys, everyone in the court very much appreciates what they're doing. That parents know that they're just not going to be able to do this for whatever reason. I recently had a surrender. It was 2 parents, and they both have mental health issues, and they've never really seen to their mental health, and they don't want to see to their mental health, and they self-medicate with drugs, and they don't want to stop. And so they just agreed that they're just not good, going to be good parents for these children, and went ahead and surrendered their rights. It's highly emotional for the parents. If you have a good relationship and you can be there to support them through that, that's good. But the judge makes it tries to make it as easy on the parents as possible. It does take place. I think she's doing them in the courtroom now. She used to do them back in a conference room to try and put the parents at ease, and only the people who have to be there so that they don't have a room full of people staring at them. After they surrender their rights, they have 3 days to change their minds. After that 3 days, it becomes final, and nothing they can do could ever change it again.
And that is not something that we as CASAs need to suggest to a parent or that parent's attorney. That is just something that needs to happen in court.
Well, there have been times too when I have asked the parent's attorney, have you maybe mentioned surrendering to your client? But yeah, it's tricky. We really don't want to talk about that and then have the parents' attorneys come down on us. A couple of things that you might run into here if you're working with teenagers are the violations docket and grip. When a youth is arrested for committing a crime or a delinquent charge would be something that would not be a crime if they were of legal age, like running away, not going to school, drinking alcohol. If they were old enough, it would not be a problem. And then there are, of course, misdemeanors and felonies. And then we also have the gang resistance intervention program for our young people and get them engaged in community activities and try to improve their position and work with their families. There's also a 207 docket if one of your CASA kids is charged with a crime and you know that they have a mental health diagnosis or maybe some type of intellectual disability. This court decides if they're mentally competent to be held responsible for that.
Really quickly, I want to do a plug. We've got folks from the 207 docket that are going to do hosting a lunch and learn for us in April on Tuesday, the 22nd at noon. So please come to that.
Okay, make note of that. And then there's Safe Baby Court. In order to get into Safe Baby Court, there has to already be, you have to have settled that DCS petition, whether it was by an agreement or by trial, that has to be already settled. And the court, Safe Baby Court, has to agree to take the family has to agree to go into the court knowing what it is. So basically it starts out with this family has a court hearing every month and a CFTM every month. It's very intense services. CASA does a short report every month. This court is currently taking place at MSAC, which is a Metro School Attendance Center out off the Trinity Lane, Ellington Parkway. Maybe if you know where the city dump is, it's out there. And Magistrate Winningham oversees that. Any questions? Sarah Camp is our specialist for Safe Baby Court. Anybody have any questions for her? Now, this court is very intense. The reason behind it is to get the baby back with the parents as quickly as possible. And when they're in Safe Baby Court, they definitely get much more visitation with the child. Then we have Family Recovery Court. This also happens after adjudication, and the parents and the magistrate must consent that this family is good fit. It has 4 phases. It's very intense. In the first phase, the parents go to court every week. Okay, move up to phase 2, it's every other week. Phase 3, every 3 weeks. Phase 4, once a month. Highly supportive. Everybody's really up in the parents' business a lot. But once again, it's to help the family, families who are serious, parents who are serious about their recovery, to help them fully. As far as the CASA report goes, you would need to check with your team leader to see, if they're in court every week. I don't know if you want to do a report every week, but your team lead will guide you on that.
Suzanne,
Mm-hmm.
can you speak to that word adjudication and just remind us what that means?
It means that the petition, okay, the allegations in the petition there's been a decision made about them. It's done. Like if kids came in because parents were using drugs, there was a trial on it or maybe a settlement, and it's already been decided that, the children were neglected because the parents were using drugs. That's the adjudication.
Thank you.
Family Recovery Court is run by Magistrate Alan Calhoun. He has done this for many years, and he's highly knowledgeable about drug recovery.
Hey,
He was at
Suzanne.
our summit, in case folks remember him from that.
Yeah, and I was just going to add too, we actually have a training for that coming up March the 5th with Jane Taylor, who kind of oversees. So you all should get a link for that. It'll be a 12 o'clock Zoom.
Yeah, all of these trainings are in our e-newsletter, so just be checking that for more information.
And then there's also truancy and educational neglect. I don't know that you would ever really much run into this. This is heard by Magistrate Alan Calhoun, also out there at Metro School Attendance Center. Typically, the children are not in DCS custody, but occasionally, if the educational neglect is the parent's fault, he will place them in custody. So we could be appointed to them at that time. What does Judge Calloway do? She hears those termination of parental rights trials and the request for a rehearing of any decision made by the magistrate that she's appointed. She also makes that horrible decision of, does a youth's criminal charges, should they be heard as an adult? Which I would not want to have to make that decision for anything. And then she can keep cases in her courtroom that she feels should stay with her. I know we have one with her where the child was murdered by the parents, and it was gruesome. And though they are both serving life sentences in prison, the grandmother has come forward, and there's kind of some question of, well, did she know about it all along? So it's really very complicated and complex, and she's keeping cases like that in her courtroom.
Suzanne,
Yes.
I missed a question earlier. Ellen asked, and I think she was talking about family treatment court. How do parents get into that program? How does that happen early on in the process? Ellen, I think you were talking about treatment court.
It can
Correct me if
happen
I'm
at any,
wrong.
it can happen at any time. Typically, like I said, there has to have been an adjudication of the original allegations. That has to all be resolved. But I had a case come in, the kids have been in custody for like 2 years. And the parents have to understand what the court is, that they're going to be in court every week for a while, be willing to do what that court expects them to do, and then Magistrate Calhoun also has to agree that yes, he thinks they'd be a good fit for that. But it can happen at any time, and it's something that you shouldn't be afraid to go to the parents' attorneys and say, "Hey, have you considered Family Recovery Court? This might be a good fit for your client," and see what they say. And then we have the foster care review boards, which you're all probably very familiar with. They meet they review the case every 6 months. Foster care review boards meet once a month at the same time on the same day, such as Foster Care Review Board 11 may meet on the fourth Monday at 9 a.m. They review the case typically every 6 months. And this is in lieu of the magistrate hearing it because the magistrate's schedules are too full. The children must attend these just like they must attend the permanency plan hearings. Other than that, they probably should not be at court unless they're, 13 or 14 and just want to be there. Then they have that right. But typically, we don't want kids at court, except for foster care review boards and permanency plans. We show up for the foster care review board. We do not do a report, but they do typically want to know what we're thinking. And you please feel free to speak up at a foster care review board because they will appreciate it.
Suzanne,
And if you notice, while they're having this board review, somebody's up there taking notes. They're filling out a specific form that goes in the court file so that when it does come before the magistrate, he can read what happened in the foster care review board. Yes, Sarah.
I have a case that I was working on where the youth did not have to attend, and I believe it was because she might be a harm to herself or others. Have you experienced any other exceptions like that?
Well, yeah, if they've just recently gone to a mental health facility and they feel that the people they're working with the child feel that it would not be good for them to go at this time, then they'll excuse that. Or in some cases, if they're far away now, I think they're may still be doing video
Yeah, we have some
attendance.
kids that are in Ohio, at a facility there. Um, and then just want to talk about therapy dogs at all on a lighter note.
Oh, yeah, go ahead. Why don't you?
Okay. So Dana Wolf at the courthouse is in charge of the therapy dog program, and you can contact her. I wish I had her info handy. I'll try to put it in the chat if I can find it. Um, so anytime a child goes to court, if you want to have a therapy dog with them, you can just request it from Dana, and hopefully she'll come through with that. There's lots of dogs in that program. If it would be nice and calming and the kids like dogs, you can request that for foster care review board and any kind of court proceeding. Thank you, Alexa. It's in the chat.
Yeah. Okay, so I think something that comes to mind is I'm always sad when I see single parents in court all by themselves. It would be okay for you to let the parents know they can bring somebody with them. They can bring a family member or a friend who's going to be supportive of them to court. It doesn't have to be just them by themselves. That's always so sad.
There's also things that you can do to get ahead of potential issues at court. What's coming to mind to me is foster care review board. They might not be aware of something that maybe should not be discussed in front of the child, or if that child needs to come in a separate entrance to the court, if their parent's not a safe person for them to be around psychologically, or if there's a court order against it. Sometimes the foster care review board doesn't always get that information in time. So you can try to get there early. I don't know, Suzanne, if you have other thoughts on that, or anybody.
Yeah, definitely. I do not hesitate at a time like that to walk in and just say, right before the court hearing, say, hey, I'm CASA. I'm on your next hearing. There's something you need to know first, and then let them know about that, or something that they're not going to want to discuss. Maybe a parent just passed away, something like that. And also about the foster care review boards, if there's something you think is really wrong, let them know. They can send a hot sheet to the magistrate and ask the magistrate to have a hearing about a specific issue as soon as possible if there's something really negative going on.
And then sometimes the younger kids in a court proceeding, they'll say, we need the kids to leave out of the courtroom at this time while we discuss whatever sensitive issue is. And they'll ask, who can watch the kids in the hallway. And we really need to, even though it's tempting to go out there and be with them, you really need to stay in the courtroom to hear what's going on and try to make sure another team member's out there with them, and make sure that there's not unsafe people in the hallway that could be interacting with them. Speaking from experience. So,
And if you know that this is going to happen at either a foster care review board or a hearing, you can let the foster parent know and ask them if there's somebody they could bring with them, another adult, to help be with the children outside.
all right, that was a lot of great information. Thank you so much, Suzanne.
You're welcome.
I think we can open, the slide says questions. Anybody have questions for Suzanne? Please don't be shy.
Could you make your slides available, either, like on 6 to a page, and maybe not one page each, but could you make those available for us?
If Sarah knows how to do that, yeah.
Yeah, I can email it. It'll just be in a regular PowerPoint template. But I can definitely email that.
Thank you.
All right. Well, if you all get to thinking of questions after the fact, hopefully everybody has my, yes, Nina, I can email them to everybody. Happy to do that. What I'll do is I'll send this to each team leader, and if you guys wouldn't mind emailing your teams, that would be appreciated. I'll send out a recording, link to the recording and the slides as well.
I had a quick,
Thank you, Suzanne.
oh, sorry, this is Barbara. I just had a quick question. Sorry. There was something that was said, and I didn't jot it down, but it was the hearings and trials that children need to be at. I mean, I know that foster care review board, they're required, but as far as all the ones that we've just listed, is the perm plan the one that Suzanne, is that what you said? And then
Yes.
okay.
Yeah, it's the permanency plan. Now, there are some times when a child's been abused and the DCS wants them to testify. We try to just get with DCS and, how can we make this as easy for them as possible? So yeah, that's where your dog comes in. That's helpful. Maybe someplace for the child to stay privately until they have to testify, that sort of thing. It's rare for a child to testify at a trial, but they may be asked. But yes, they have to be at permanency plan hearings and foster care review boards. And if say the perm plan hearings coming up and the foster family's going to Disney World, get with the guardian ad litem and the court clerk, whomever, and say, hey, can we make it another time? The magistrates, if there's a good reason, will set a separate time to see the children. other than the permanency plan. If you know the parents are going to be there and it's just going to be too hard on the children to see them, then ask for a separate date and time. And yeah, but that needs to be done before the perm plan hearing.
Okay. Thank you.
Mhm.
We would probably want to reach out to, in that case, the DCS attorney for that courtroom, I'm thinking.
That's probably the best idea. Yeah.
Yeah. So you can talk to your team leader about that and who to reach out to in those instances. And it occurs to me that maybe folks who might be watching the recording can't see the chat. And if you want that contact info for the therapy dog program, it's Dana Wolf with an E. So DANAWOLFE at JISNashville.gov. Thank you for your question, Barbara. And I just want to give a shout out to Barbara in general lately. She's been helping us out so much above and beyond regular CASA work. Not that there's anything such as regular CASA work, but just helping out at the office and some things internally. So I wanted to give her a shout out.
Well, yeah. I have a question since I'm going to a prelim in just about 30 minutes. And maybe this kind of relates to the prelim Suzanne thing. Just to clarify for me, if, for example, one today is going to have, I think, the maternal grandmother there, just to clarify in my brain, do we take cases if it is placed with a relative?
And not typically.
Okay.
Typically, we have in past years we did, but right now our program's more focused on serving children who are in foster care.
Okay. All right. So okay, well, I'll maybe have a conversation with you, Sarah, about, how I fill out this intake form because I want to be sure I do it right. Okay, thank you.
Okay, but that being said, the grandmother may opt to become a foster parent so that they can get the financial benefits, so that the child can get on TennCare. So in that case, yes, we could.
Okay. So, and that will happen in the net, whatever. I mean, it takes a little time for that, I guess, but down the road. Okay.
Sometimes they'll go ahead and do an expedited placement without them having gone through all the foster parent training. And they'll go ahead and, do all the background checks and so forth and place the child with the grandparent with the understanding that they will take the foster parent training as soon as possible.
Okay. One last question now that we're saying this in the prelim. Today, one of the prelims is a 17-year-old at the hospital. So, what if you were assigned this case and anyway, a lot of details, she may be in the hospital for a while. Is that wow, I don't know. I guess that's too specific.
That would be for the CASA team. Yeah, that would be for the CASA staff to decide, is it a mental health hospital? Is it
no, it's Vanderbilt's Children's
Vanderbilt? Okay. The child, and looking at it and see, could the child use the support of a CASA right now? If nobody else is visiting them at the hospital, so that the CASA staff will make that decision of which cases to serve.
Okay. All right. Thank you.
Mhm.
Oh, and then Melody said she has a case where the child is placed with a relative, but it's a safe baby case. There was a time where we were serving a lot more. Or Sarah, I don't know if you want to speak to that.
Sure, yeah. I know that a while back we were serving some non-custodial cases and safe babies. And so we still have a few of those. But right now we're kind of still really trying to prioritize kids that aren't placed with any kind of relative, just because if they're with a relative, whether that's formally or not, that relative is advocating for them. And so we try to put our advocacy places where maybe they don't have that.
Thank you. Any last questions? All right. Well, Suzanne, you're my hero. Thank you for doing this for us. I
Glad to
appreciate
do
all
it.
of y'all for coming. And like I said, I'll get that recording and the slides out. And everybody have a wonderful rest of your day. Thanks for being here.
Thanks, Suzanne.
Thank you.
Thanks.